Listening Practice, Business Law Part 1, Introduction to Business Law Chapter 1, What is Business Law? 1. Definition and importance of business law. Business law, also known as commercial law, encompasses the legal rules and regulations that govern the formation, operation, and dissolution of businesses. It provides a framework for conducting business transactions, resolving disputes, and ensuring compliance with legal standards. Business law is essential for maintaining order, protecting rights, and fostering trust in commercial relationships. The importance of business law lies in its ability to ensure legal compliance. Businesses must adhere to various laws and regulations to avoid legal penalties and maintain their reputation. Protect rights and interests. It safeguards the rights of businesses, employees, consumers, and other stakeholders. Facilitate transactions. Clear legal guidelines help in the smooth execution of contracts and agreements. Resolve disputes. It provides mechanisms for resolving conflicts through litigation, arbitration, or mediation. 2 key areas of business law. Business law covers a wide range of legal disciplines, each addressing different aspects of business operations. The key areas include: contract law, governs the creation and enforcement of agreements between parties. It ensures that contracts are legally binding and that parties fulfill their obligations. Corporate law, deals with the formation, governance, and dissolution of corporations. It includes issues related to corporate structure, shareholder rights, and mergers and acquisitions. Employment law, regulates the relationship between employers and employees. It covers areas such as labor rights, workplace safety, discrimination, and employment contracts. Intellectual property law, protects creations of the mind, such as inventions, trademarks, copyrights, and trade secrets. It ensures that creators can benefit from their innovations and prevents unauthorized use. 3. The role of business law in organizational success. Business law plays a crucial role in the success of organizations by providing a stable and predictable legal environment. It helps businesses mitigate risks. By understanding and complying with legal requirements, businesses can avoid legal disputes and financial losses. Enhance credibility. Adhering to legal standards builds trust with customers, investors, and partners. Facilitate growth. Clear legal frameworks enable businesses to expand, enter new markets, and engage in international trade. Ensure fair practices. Business law promotes ethical behavior and fair competition, contributing to a healthy business ecosystem. In summary, business law is integral to the functioning and success of any organization. It provides the necessary legal infrastructure for businesses to operate efficiently, protect their interests, and achieve their goals. Chapter 2: The legal environment of business. The legal environment of business refers to the framework of laws, regulations, and institutions that shape how businesses operate. It ensures fairness, accountability, and stability in commercial activities. This chapter explores the legal system, sources of business law, and the role of government and regulatory agencies. 1. Understanding the legal system. The legal system provides the structure for creating, interpreting, and enforcing laws. It ensures that businesses and individuals operate within a defined set of rules. Key components of the legal system include: civil law versus common law. Civil law systems rely on written codes and statutes as the primary source of law. Judges interpret these codes but have limited authority to create new laws. Common law systems, for example, the US, UK, are based on judicial precedents and case law, where courts interpret statutes and establish legal principles through rulings. Federal versus state law. In countries like the US, the legal system is divided into federal and state levels. Federal laws apply nationwide, while state laws govern issues within individual states. Courts and jurisdiction. Courts resolve disputes and interpret laws. Jurisdiction determines which court has the authority to hear a case, based on factors like geography, subject matter, or the parties involved. 2. Sources of business law. Business law derives from multiple sources, each contributing to the legal framework that governs commercial activities. The primary sources include statutes, laws enacted by legislative bodies, for example, Congress, Parliament. Examples include the U.S. Uniform Commercial Code, UCC, and the Companies Act in the UK. Statutes provide clear rules for business operations, such as contract formation, corporate governance, and consumer protection. Regulations, rules and guidelines created by regulatory agencies to implement statutes. For example, the Securities and Exchange Commission, SEC, enforces regulations on financial markets. Regulations provide detailed instructions on how businesses must comply with broader statutory requirements. Case law, judicial decisions that interpret statutes and regulations. Courts establish precedents that guide future rulings and clarify legal principles. For example, landmark cases like Marbury v. Madison, U.S., or Salomon v. A. Salomon and Company Limited, UK, have shaped corporate and constitutional law. International law, treaties, conventions, and agreements between countries that affect global business operations. Examples include the World Trade Organization, WTO, rules and the Paris Agreement on Climate Change. 3. The role of government and regulatory agencies. Governments and regulatory agencies play a critical role in shaping the legal environment of business. Their functions include creating laws and regulations. Legislatures pass laws, while regulatory agencies develop specific rules to enforce them. For example, the Environmental Protection Agency, EPA, creates regulations to enforce environmental laws. Enforcing compliance, agencies monitor businesses to ensure compliance with laws and regulations. Non-compliance can result in penalties, fines, or legal action. Examples include the Federal Trade Commission, FTC, which enforces consumer protection laws, and the Occupational Safety and Health Administration, OSHA, which ensures workplace safety. Promoting fair competition, agencies like the Federal Trade Commission, FTC, and the European Commission enforce antitrust laws to prevent monopolies and promote fair competition. Protecting stakeholders, governments and agencies protect the interests of consumers, employees, investors, and the public. For example, the Consumer Financial Protection Bureau, CFPB, safeguards consumers from unfair financial practices. Resolving disputes, courts and administrative bodies resolve disputes between businesses, individuals, and government entities. This ensures that conflicts are settled fairly and in accordance with the law. Conclusion: the legal environment of business is a complex but essential framework that ensures businesses operate ethically, responsibly, and within the bounds of the law. By understanding the legal system, sources of business law, and the role of government and regulatory agencies, businesses can navigate legal challenges, mitigate risks, and contribute to a fair and competitive marketplace. Chapter 3: Ethical Considerations in Business Law. Ethics and law are deeply intertwined in the business world. While laws provide a formal framework for acceptable behavior, ethics guide moral decision-making beyond what is legally required. This chapter explores the intersection of law and ethics, common ethical dilemmas in business law, and strategies for promoting ethical legal practices. 1. The intersection of law and ethics. Law as a minimum standard. Laws establish the minimum standards of behavior that businesses must follow. For example, labor laws set minimum wage requirements, and environmental laws regulate pollution levels. However, compliance with the law does not always equate to ethical behavior. Businesses must go beyond legal requirements to act responsibly and ethically. Ethics as a guiding principle. Ethics involves moral principles that influence decision-making. Ethical behavior often exceeds legal requirements and focuses on fairness, honesty, and social responsibility. For example, a company may legally avoid taxes through loopholes, but doing so may be considered unethical if it harms society. Balancing law and ethics. Businesses must navigate situations where legal and ethical considerations conflict. For instance, a company may legally outsource labor to countries with lower wages, but ethical concerns may arise regarding worker exploitation. 2. Ethical dilemmas in business law. Ethical dilemmas occur when businesses face conflicting interests or values. Common dilemmas in business law include conflicts of interest, situations where personal interests conflict with professional duties. For example, a manager awarding a contract to a family member's company may be legal but unethical. Whistleblowing. Employees who expose illegal or unethical practices within their organization may face retaliation, even though their actions are morally justified. Laws like the Whistleblower Protection Act aim to protect such individuals. Corporate social responsibility, CSR. Businesses may face dilemmas between maximizing profits and acting in the best interest of society. For example, a company may legally cut costs by reducing environmental protections, but doing so could harm the community. Data privacy and security. Companies collecting customer data must balance legal compliance, for example, GDPR, with ethical concerns about privacy and transparency. Intellectual property. While businesses have legal rights to protect their intellectual property, ethical issues arise when enforcing these rights stifles innovation or limits access to essential resources, for example, life-saving drugs. 3. Promoting ethical legal practices to foster ethical behavior. Businesses can adopt the following strategies. Establish a code of ethics. A formal code of ethics outlines the organization's values and expectations for ethical behavior. It serves as a guide for decision-making and helps employees navigate complex situations. Ethics training. Regular training programs can educate employees about ethical standards, legal requirements, and how to handle ethical dilemmas. Encourage transparency and accountability. Open communication and accountability mechanisms, such as anonymous reporting systems, can help identify and address unethical behavior. Leadership by example. Leaders play a critical role in setting the tone for ethical behavior. When executives model ethical decision-making, it encourages employees to follow suit. Stakeholder engagement. Engaging with stakeholders, for example, employees, customers, communities, helps businesses understand the ethical implications of their actions and make more responsible decisions. Corporate social responsibility, CSR, initiatives. CSR programs demonstrate a commitment to ethical practices by addressing social, environmental, and economic issues. Examples include sustainable sourcing, charitable donations, and community development projects. Legal and ethical audits. Regular audits can help businesses identify areas where their practices may fall short of legal or ethical standards and take corrective action. Conclusion. Ethical considerations are integral to business law, as they ensure that businesses not only comply with legal requirements but also act in a socially responsible manner. By understanding the intersection of law and ethics, addressing ethical dilemmas, and promoting ethical practices, businesses can build trust, enhance their reputation, and contribute to a more just and sustainable society. Part 2. Contract Law. Chapter 4. Introduction to Contract Law. Contract law is a fundamental area of business law that governs agreements between parties. It ensures that promises made in a business context are enforceable, providing stability and predictability in commercial relationships. This chapter introduces the definition and importance of contracts, the key elements of a valid contract, and the different types of contracts. 1. Definition and importance of contracts. Definition: a contract is a legally binding agreement between two or more parties that creates obligations enforceable by law. It can involve the exchange of goods, services, money, or promises. Importance: legal enforcement. Contracts provide a legal framework for enforcing agreements, ensuring that parties fulfill their obligations. Clarity and certainty: they clearly outline the terms and conditions of an agreement, reducing the risk of misunderstandings. Risk management: contracts allocate risks between parties, specifying remedies in case of breach or non-performance. Facilitates commerce: by providing a reliable mechanism for enforcing agreements, contracts enable businesses to engage in transactions with confidence. 2. Key elements of a valid contract. For a contract to be legally enforceable, it must contain the following essential elements. Offer: an offer is a clear and definite proposal made by one party, the offerer, to another, the offee, with the intention to be bound by it. It must communicate the terms of the agreement and demonstrate an intention to enter into a contract. Example: a seller offers to sell a car to a buyer for $10,000. Acceptance: acceptance is the offeree's agreement to the terms of the offer. It must be unconditional and communicated to the offerer. Example: the buyer agrees to purchase the car for $10,000 without any changes to the offer. Consideration: consideration refers to something of value exchanged between the parties. It can be money, goods, services, or a promise to do, or not do, something. Example: the buyer pays $10,000, and the seller transfers ownership of the car. Mutual intent: both parties must intend to create a legally binding agreement. This is often inferred from their actions and the context of the agreement. Capacity: the parties must have the legal capacity to enter into a contract. This means they must be of legal age, mentally competent, and not under duress or undue influence. Legality: the subject matter of the contract must be legal. Agreements involving illegal activities, for example, drug trafficking, are not enforceable. 3 types of contracts. Contracts can take various forms, depending on how they are created and expressed. The main types include written contracts. These are formal agreements documented in writing. They are preferred in business because they provide clear evidence of the terms and reduce the risk of disputes. Examples: employment contracts, lease agreements, sales contracts. Oral contracts: these are verbal agreements between parties. While they are legally binding in many cases, they can be difficult to enforce due to the lack of written evidence. Examples: a handshake agreement to sell a used item. Implied contracts: these contracts are not explicitly stated but are inferred from the parties' actions or conduct. They are based on the principle of fairness and reasonable expectations. Example: a customer sitting at a restaurant and ordering food implies an agreement to pay for the meal. Express contracts. These contracts are explicitly stated, either orally or in writing. The terms are clearly communicated by the parties. Example, a signed agreement to purchase a house. Unilateral contracts. These involve a promise made by one party in exchange for the performance of an act by another party. Only one party is legally obligated until the act is performed. Example, a reward offer for finding a lost pet. Bilateral contracts. These involve mutual promises between two parties, where both are obligated to perform their respective duties. Example, a contract to buy goods, where the seller promises to deliver the goods, and the buyer promises to pay. Conclusion. Contract law is the backbone of business transactions, providing a legal framework for creating and enforcing agreements. By understanding the definition and importance of contracts, the key elements required for a valid contract, and the different types of contracts, businesses can ensure that their agreements are clear, enforceable, and aligned with their objectives. This foundation is essential for building trust and minimizing risks in commercial relationships. Chapter 5. Formation of contracts. The formation of a contract is a critical process that establishes the legal relationship between parties. This chapter explores the steps involved in contract formation, the concepts of offer and acceptance, and the role of consideration and mutual consent in creating a valid and enforceable agreement. 1. The process of contract formation. The formation of a contract involves several stages, each of which must meet specific legal requirements. The process typically includes negotiation. Parties discuss the terms of the agreement, including their respective rights and obligations. This stage may involve proposals, counteroffers, and revisions. Offer. One party, the offerer, makes a clear and definite proposal to another party, the offee, with the intention to be bound by it. Acceptance. The offee agrees to the terms of the offer without any modifications, creating a mutual agreement. Consideration. Both parties exchange something of value, such as money, goods, services, or promises. Mutual consent. Both parties must genuinely agree to the terms of the contract, demonstrating a meeting of the minds. Formalization. If applicable, some contracts must be in writing or meet other formal requirements to be enforceable, for example, real estate contracts. 2. Understanding offer and acceptance. Offer. An offer is a clear, definite, and communicated proposal by the offerer to enter into a contract under specific terms. It must demonstrate an intention to be bound and include all essential terms. Key characteristics of an offer. It must be communicated to the offee. It must be specific and complete, for example, price, quantity, and subject matter. It must indicate the offerer's intention to be bound upon acceptance. Examples: a seller offers to sell a car for $15,000. A company offers a job to a candidate with a specified salary and start date. Acceptance. Acceptance is the offee's unqualified agreement to the terms of the offer. It must be communicated to the offerer and match the terms of the offer exactly, the mirror image rule. Key characteristics of acceptance: it must be unconditional and unequivocal. It must be communicated to the offerer, unless the offer specifies otherwise. It must occur before the offer expires or is revoked. Examples: the buyer agrees to purchase the car for $15,000 without any changes. The candidate accepts the job offer under the specified terms. Termination of an offer. An offer can end through revocation, withdrawal by the offerer. Rejection, by the offee. Lapse of time, expiration of the offer. Death or incapacity of the offerer. 3. The role of consideration and mutual consent. Consideration. Consideration is the value exchanged between the parties, which makes the contract legally enforceable. It can be money, goods, or services. A promise to do, or not do, something. Consideration must be something of value, but it does not need to be equal or fair in monetary terms. Examples: in a sales contract, the buyer's payment is consideration for the seller's goods. In an employment contract, the employee's work is consideration for the employer's salary. Mutual consent, also known as a meeting of the minds, means that both parties understand and agree to the same terms of the contract. It ensures that the agreement is voluntary and not based on coercion, fraud, or misrepresentation. Key aspects of mutual consent: both parties must have the capacity to enter into the contract. The terms of the contract must be clear and unambiguous. There must be no undue influence, duress, or misrepresentation. Examples: a landlord and tenant agree on the terms of a lease, including rent and duration. A supplier and buyer agree on the price and delivery schedule for goods. Conclusion: the formation of a contract is a structured process that requires a clear offer, unconditional acceptance, valid consideration, and mutual consent. By understanding these elements, businesses and individuals can create enforceable agreements that protect their rights and obligations. Proper contract formation minimizes the risk of disputes and ensures that parties can rely on the terms of their agreements. The terms and conditions of a contract define the rights, obligations, and expectations of the parties involved. Clear and well-drafted terms are essential to avoid disputes and ensure enforceability. This chapter explores the differences between express and implied terms, standard contract clauses, and best practices for drafting clear and enforceable contracts. 1. Express and implied terms. Express terms. Express terms are explicitly stated and agreed upon by the parties, either in writing or orally. They form the core of the contract and include specific details such as price, quantity, and delivery dates. Examples: a sales contract stating, the buyer will pay $10,000 for 100 units of product X, delivered by March 1, 2025. An employment contract specifying, the employee will receive an annual salary of $50,000, payable in monthly installments. Implied terms. Implied terms are not explicitly stated but are inferred by law, custom, or the conduct of the parties. They are included to ensure fairness or to reflect the parties' intentions. Types of implied terms. Terms implied by law. Certain terms are automatically included in contracts by statute or common law. For example, in a sale of goods, there is an implied warranty that the goods are of satisfactory quality. Terms implied by custom. Industry practices or trade customs may imply terms. For example, in construction contracts, it may be customary to include a clause for delays caused by weather. Terms implied by fact. These terms are inferred based on the parties' intentions and the context of the agreement. For example, in a lease agreement, it may be implied that the landlord will maintain the property in a habitable condition. Examples: a contract for the sale of a car implies that the car is roadworthy. A contract for professional services implies that the service provider will perform their duties with reasonable skill and care. 2. Standard contract clauses. Standard clauses are commonly included in contracts to address specific issues and protect the parties' interests. Key clauses include warranties. Warranties are promises or guarantees about the quality, performance, or condition of goods or services. They provide assurance to the buyer and create legal obligations for the seller. Examples: a warranty that a product is free from defects for 1 year. a warranty that a service will be performed to a professional standard. Indemnities. Indemnity clauses require one party to compensate the other for specific losses, damages, or liabilities. They are often used to allocate risk between the parties. Examples: a contractor agrees to indemnify the client for any damages caused by their work. A supplier agrees to indemnify the buyer for any legal claims arising from defective products. Limitation of liability. These clauses limit the amount or type of liability one party can face in case of a breach or other issues. They are used to cap potential losses and manage risk. Examples: a software provider limits its liability to the amount paid by the customer for the software. A service provider excludes liability for indirect or consequential damages. Other common clauses: force majeure, excuses performance in case of unforeseen events, for example, natural disasters, war. Confidentiality, protects sensitive information shared between the parties. Termination, specifies the conditions under which the contract can be ended. Dispute resolution, outlines the process for resolving disputes, such as arbitration or mediation. 3 ***, drafting clear and enforceable contracts. To ensure that contracts are clear, enforceable, and effective, follow these best practices. 1. Use clear and precise language, avoid ambiguous or vague terms. Define key terms and use simple, straightforward language. Example: instead of "the product will be delivered soon," specify "the product will be delivered within 30 days of the contract date." 2. Include all essential terms. Ensure that the contract covers all critical aspects of the agreement, such as payment terms, delivery schedules, and performance standards. 3. Address potential risks. Include clauses that allocate risks and responsibilities, such as indemnities, limitation of liability, and force majeure. 4. Be specific about obligations. Clearly outline the duties and responsibilities of each party to avoid misunderstandings. Example: the contractor will complete the construction project by the 31st of December, 2025, and provide weekly progress reports. 5. Ensure compliance with legal requirements. Verify that the contract complies with relevant laws and regulations, such as consumer protection laws or industry-specific standards. 6. Review and revise. Carefully review the contract for accuracy, completeness, and consistency. Seek legal advice if necessary. 7. Obtain mutual consent. Ensure that both parties fully understand and agree to the terms before signing. This demonstrates mutual consent and reduces the risk of disputes. Conclusion: the terms and conditions of a contract are the foundation of a legally binding agreement. By understanding the differences between express and implied terms, incorporating standard clauses, and drafting clear and enforceable contracts, businesses can protect their interests, minimize risks, and foster trust in their commercial relationships. A well-drafted contract not only ensures compliance with legal requirements but also provides a roadmap for successful and dispute-free transactions. A breach of contract occurs when one party fails to fulfill their obligations under the agreement, leading to potential legal consequences. This chapter explores the concept of breach of contract, the legal remedies available, and strategies for mitigating risks in contractual relationships. 1. Understanding breach of contract. A breach of contract happens when one or more parties fail to perform their duties as outlined in the agreement. Breaches can vary in severity and impact, and they are generally categorized as follows: material breach, a significant failure to perform that undermines the core purpose of the contract. The non-breaching party is excused from their obligations and may seek remedies. Example, a contractor fails to complete a construction project by the agreed deadline, causing significant financial loss to the client. Minor breach, partial breach, a less severe failure that does not completely derail the contract. The non-breaching party is still required to perform but may seek compensation for the breach. Example, a supplier delivers goods 1 day late, but the delay does not significantly impact the buyer's operations. Anticipatory breach occurs when one party indicates, through words or actions, that they will not fulfill their contractual obligations before the performance is due. Example, a seller informs the buyer that they will not deliver the goods as promised, even before the delivery date. Actual breach occurs when a party fails to perform their obligations on the due date or during the performance period. Example, a service provider fails to provide the agreed upon services on the scheduled date. 2. Legal remedies for breach. When a breach occurs, the non-breaching party may seek legal remedies to address the harm caused. The primary remedies include damages. Damages are monetary compensation awarded to the non-breaching party to cover losses resulting from the breach. Types of damages include compensatory damages, intended to cover direct losses, for example, lost profits, costs incurred. Consequential damages cover indirect losses that were foreseeable at the time of contract formation, for example, lost business opportunities. Liquidated damages, pre-agreed amounts specified in the contract to compensate for a breach, for example, a penalty for late delivery. Punitive damages, rare in contract law, these are intended to punish the breaching party for egregious conduct. Specific performance, a court order requiring the breaching party to fulfill their contractual obligations. This remedy is typically used when monetary damages are insufficient, such as in cases involving unique goods or property. Example, a court orders a seller to transfer ownership of a rare painting to the buyer as agreed in the contract. Rescission, the contract is cancelled, and both parties are released from their obligations. This remedy is used when the breach is so significant that the contract cannot be salvaged. Example, a buyer rescinds a contract after discovering that the seller misrepresented the quality of the goods. Reformation, the court modifies the contract to reflect the parties' original intentions. This remedy is used when the contract contains errors or misrepresentations. Example, a court corrects a typographical error in a contract that led to a misunderstanding. Injunction, a court order preventing a party from taking certain actions that would violate the contract. Example, a court issues an injunction to stop a former employee from sharing confidential information in violation of a non-disclosure agreement. 3. Mitigating risks in contractual relationships. To minimize the risk of breaches and disputes, businesses can adopt the following strategies. 1. Draft clear and detailed contracts. Ensure that the contract clearly outlines the rights, obligations, and expectations of all parties. Include specific terms for performance, deadlines, and remedies for breach. 2. Include dispute resolution clauses. Specify how disputes will be resolved, such as through mediation, arbitration, or litigation. This can save time and costs if a breach occurs. 3. Conduct due diligence. Research the other party's reputation, financial stability, and track record before entering into a contract. This reduces the risk of dealing with unreliable parties. 4. Monitor performance. Regularly track the progress of contractual obligations to identify potential issues early and address them before they escalate. 5. Include risk allocation clauses. Use clauses such as limitation of liability, indemnities, and force majeure to allocate risks and protect against unforeseen events. 6. Maintain communication. foster open and transparent communication with the other party to address concerns and resolve issues promptly. 7. Seek legal advice. Consult legal professionals to ensure that contracts are enforceable and comply with relevant laws and regulations. Conclusion: breach of contract can have significant legal and financial consequences, but understanding the types of breaches and available remedies can help parties protect their interests. By drafting clear contracts, including risk mitigation clauses, and maintaining open communication, businesses can reduce the likelihood of breaches and foster stronger, more reliable contractual relationships. When breaches do occur, legal remedies such as damages, specific performance, and rescission provide avenues for redress and ensure that parties are held accountable for their obligations. Chapter 8: Special types of contracts. Contracts are used in various contexts, each with its own unique requirements and legal considerations. This chapter explores 3 special types of contracts: employment contracts, sales contracts governed by the Uniform Commercial Code, UCC, Article 2, and lease and rental agreements. 1. Employment contracts. Employment contracts define the relationship between employers and employees, outlining the terms and conditions of employment. They provide clarity and legal protection for both parties. Key elements of employment contracts: job description specifies the employee's role, responsibilities, and duties. Compensation details the salary, wages, bonuses, and other forms of payment. Benefits includes health insurance, retirement plans, vacation time, and other perks. Duration specifies whether the employment is at will, fixed term, or indefinite. Termination clauses outlines the conditions under which the contract can be terminated, including notice periods and severance pay. Confidentiality and non-compete clauses protects the employer's proprietary information and restricts the employee's ability to work for competitors. Importance of employment contracts: they provide legal protection for both employers and employees. They clarify expectations and reduce the risk of disputes. They ensure compliance with labor laws and regulations. Example: an employment contract for a software engineer might include a job description, a salary of $80,000 per year, health insurance benefits, a 2-year term, and a non-compete clause valid for 1 year after termination. 2. Sales contracts. UCC Article 2. Sales contracts govern the sale of goods and are primarily regulated by Article 2 of the Uniform Commercial Code, UCC, in the United States. The UCC provides a standardized set of rules for commercial transactions, ensuring consistency and fairness. Key provisions of UCC Article 2. Formation of contracts. A sales contract can be formed in any manner that shows agreement, including conduct. It does not require a formal written agreement, except in certain cases, for example, sales over $500. Merchant rules. Special rules apply to transactions involving merchants, those who regularly deal in goods of the kind sold. Warranties. The UCC implies certain warranties in sales contracts, such as the warranty of merchantability, goods are fit for their ordinary purpose, and the warranty of fitness for a particular purpose, goods are suitable for a specific use. Remedies for breach. The UCC provides remedies for buyers and sellers in case of breach, including damages, specific performance, and the right to reject non-conforming goods. Importance of UCC Article 2. It provides a clear and consistent framework for sales transactions. It protects buyers and sellers by establishing default rules and remedies. It facilitates commerce by reducing the need for detailed negotiations in every transaction. Example, a sales contract for 100 laptops might specify the price, $50,000, delivery date, within 30 days, and warranty, 1 year for parts and labor. If the laptops are defective, the buyer can reject them or seek damages under the UCC. 3. Lease and rental agreements. Lease and rental agreements govern the use of property, real or personal, in exchange for payment. They are commonly used for residential, commercial, and equipment rentals. Key elements of lease and rental agreements: parties, identifies the lessor, owner, and lessee, user. Property description, specifies the property being leased, for example, address, equipment details. Term, defines the duration of the lease, for example, 1 year, month to month. Rent forward/payment, details the amount, due date, and method of payment. Security deposit, specifies the amount and conditions for return. Maintenance and repairs, outlines the responsibilities of the lessor and lessee. Termination clauses, specifies the conditions under which the lease can be terminated, including notice periods and penalties. Types of lease agreements: residential leases, govern the rental of apartments, houses, or other living spaces. Commercial leases, govern the rental of office space, retail stores, or industrial properties. Equipment leases, govern the rental of machinery, vehicles, or other equipment. Importance of lease and rental agreements: they provide legal protection for both lessors and lessees. They clarify the terms and conditions of the rental, reducing the risk of disputes. They ensure compliance with landlord-tenant laws and regulations. Example, a residential lease agreement might specify a 1-year term, monthly rent of $1,500, a security deposit of $1,500, and the lessee's responsibility for minor repairs. If the lessee fails to pay rent, the lessor can terminate the lease and seek eviction. Conclusion: special types of contracts, such as employment contracts, sales contracts under UCC Article 2, and lease and rental agreements, play a crucial role in various aspects of business and personal life. By understanding the unique requirements and legal considerations of each type, parties can create clear, enforceable agreements that protect their interests and foster positive relationships. Whether hiring employees, selling goods, or leasing property, well-drafted contracts provide the foundation for successful and dispute-free transactions. Part 3, Corporate Law. Chapter 9, Introduction to Corporate Law. Corporate law governs the formation, operation, and dissolution of corporations. It provides the legal framework for businesses to operate as separate legal entities, protecting the rights and responsibilities of shareholders, directors, and other stakeholders. This chapter introduces the definition and importance of corporate law, key concepts, and its role in business operations. 1. Definition and importance of corporate law. Definition: corporate law is a body of laws, rules, and regulations that govern the formation, management, and dissolution of corporations. It covers issues such as corporate governance, shareholder rights, and fiduciary duties. Importance: legal entity status. Corporate law allows businesses to operate as separate legal entities, distinct from their owners. This provides limited liability protection to shareholders. Investor confidence. Clear legal frameworks attract investors by ensuring transparency, accountability, and protection of their rights. Regulation of corporate behavior. Corporate law sets standards for ethical and responsible business practices, promoting fairness and sustainability. Dispute resolution. It provides mechanisms for resolving disputes between shareholders, directors, and other stakeholders. Two key concepts in corporate law. Incorporation. Incorporation is the process of legally forming a corporation. It involves filing documents, for example, articles of incorporation, with the relevant government authority and complying with legal requirements. Key steps in incorporation: choose a business name and ensure it is unique. Draft and file articles of incorporation, which outline the corporation's purpose, structure, and initial shareholders. Issue shares to shareholders and establish bylaws, internal rules governing the corporation. Obtain necessary licenses and permits. Benefits of incorporation: limited liability for shareholders. Perpetual existence: the corporation continues even if ownership changes. Ability to raise capital by issuing shares. Corporate governance. Corporate governance refers to the system of rules, practices, and processes by which a corporation is directed and controlled. It involves balancing the interests of shareholders, management, and other stakeholders. Key components of corporate governance: Board of Directors, elected by shareholders to oversee management and make major decisions. Officers, appointed by the board to manage day-to-day operations, for example, CEO, CFO. Shareholders, owners of the corporation who have voting rights and receive dividends. Fiduciary duties: directors and officers owe duties of care, loyalty, and good faith to the corporation and its shareholders. Importance of corporate governance: ensures accountability and transparency. Protects shareholder rights. Promotes ethical and sustainable business practices. 3. The role of corporate law in business operations. Corporate law plays a critical role in shaping how businesses operate and interact with stakeholders. Its functions include: 1. Facilitating business formation. Corporate law provides the legal framework for creating corporations, enabling entrepreneurs to establish businesses with limited liability and access to capital. 2. Regulating corporate structure. It defines the roles and responsibilities of directors, officers, and shareholders, ensuring clear lines of authority and accountability. 3. Protecting stakeholder rights. Corporate law safeguards the rights of shareholders, employees, creditors, and other stakeholders by setting standards for fair treatment and transparency. 4. Ensuring compliance. It requires corporations to comply with legal and regulatory requirements, such as filing annual reports, holding shareholder meetings, and maintaining accurate records. 5. Managing corporate transactions. Corporate law governs mergers, acquisitions, and other transactions, ensuring they are conducted fairly and in compliance with legal standards. 6. Resolving disputes. It provides mechanisms for resolving disputes between stakeholders, such as shareholder lawsuits or board conflicts. 7. Promoting ethical practices. Corporate law encourages ethical behavior by imposing fiduciary duties on directors and officers and requiring transparency in financial reporting. Conclusion: corporate law is the foundation of modern business operations, providing the legal framework for corporations to function effectively and responsibly. By understanding key concepts such as incorporation and corporate governance, businesses can ensure compliance, protect stakeholder rights, and promote sustainable growth. Whether forming a new corporation, managing day-to-day operations, or navigating complex transactions, corporate law plays a vital role in shaping the success and integrity of businesses. Chapter 10: Formation and Structure of Corporations. The formation and structure of corporations are critical steps in establishing a business as a separate legal entity. This chapter explores the steps to incorporate a business, the types of business entities, and the importance of corporate bylaws and articles of incorporation. 1. Steps to incorporate a business. Incorporating a business involves several legal and administrative steps to establish it as a separate legal entity. The process typically includes: 1. Choose a business name. Select a unique name that complies with state naming requirements. For example, it must include Corporation Incorporated or an abbreviation like Inc. Conduct a name search to ensure the name is not already in use. 2. Appoint directors. Identify the initial directors who will oversee the corporation until the first shareholder meeting. 3. File articles of incorporation. Submit the articles of incorporation, also called a certificate of incorporation, to the appropriate state agency. This document typically includes the corporation's name and address, the purpose of the corporation, the number and type of shares authorized, the names and addresses of the incorporators. 4. Draft corporate bylaws. Create bylaws, which are internal rules governing the corporation's operations, including procedures for holding meetings, roles and responsibilities of directors and officers, voting and decision-making processes. 5. Hold an organizational meeting. Conduct the first meeting of the board of directors to adopt the bylaws. Issue shares to initial shareholders. Appoint officers, for example, CEO, CFO. 6. Obtain necessary licenses and permits. Secure any required federal, state, or local licenses and permits to operate legally. 7. Comply with tax and regulatory requirements. Obtain an employer identification number, EIN, from the IRS. Register for state and local taxes. File annual reports and pay franchise taxes as required. 2. Types of business entities. Businesses can choose from several types of legal structures, each with its own advantages and disadvantages. The most common types include: 1. Limited liability company, LLC. Features: combines the liability protection of a corporation with the tax benefits of a partnership. Owners, called members, are not personally liable for the company's debts. Advantages: flexible management structure. Pass-through taxation. Profits are taxed at the member level, not the entity level. Disadvantages: more complex to set up than a sole proprietorship or partnership. Limited life, may dissolve if a member leaves. 2. Corporation. Features: a separate legal entity owned by shareholders. Provides limited liability protection to shareholders. Advantages: ability to raise capital by issuing shares. Perpetual existence, not affected by changes in ownership. Disadvantages: double taxation, profits taxed at the corporate level and dividends taxed at the shareholder level. More regulatory requirements and administrative complexity. 3. Partnership. Features: a business owned by 2 or more individuals, partners. Can be general, all partners manage the business and are personally liable, or limited. Some partners have limited liability and no management role. Advantages: easy to establish and manage. Pass-through taxation. Disadvantages: personal liability for general partners. Potential for disputes between partners. 4. Sole proprietorship. Features: a business owned and operated by one individual. Advantages: simple and inexpensive to set up. Complete control over business decisions. Disadvantages: unlimited personal liability. Limited ability to raise capital. 3. Understanding corporate bylaws and articles of incorporation. Articles of incorporation. The articles of incorporation are the primary legal document filed with the state to formally create a corporation. They include the corporation's name and purpose, the number and type of shares authorized, the names and addresses of the incorporators, The registered agent, a person or entity designated to receive legal documents. Purpose, establishes the corporation's existence and basic structure. Provides transparency to shareholders, regulators, and the public. Corporate bylaws. Bylaws are internal rules that govern the corporation's operations and management. They typically include procedures for electing directors and officers, rules for holding shareholder and board meetings, voting requirements and decision-making processes, policies for issuing and transferring shares. Purpose, ensures consistent and efficient management of the corporation. Provides clarity on roles, responsibilities, and procedures. Helps resolve disputes by establishing clear guidelines. Conclusion: the formation and structure of corporations are essential steps in establishing a business as a separate legal entity. By following the steps to incorporate, choosing the appropriate business entity, and drafting clear articles of incorporation and bylaws, businesses can ensure compliance with legal requirements, protect stakeholders' interests, and create a solid foundation for growth. Whether forming a corporation, LLC, partnership, or sole proprietorship, understanding these concepts is key to building a successful and sustainable business. Chapter 10: Formation and Structure of Corporations. The formation and structure of corporations are critical steps in establishing a business as a separate legal entity. This chapter explores the steps to incorporate a business, the types of business entities, and the importance of corporate bylaws and articles of incorporation. 1**** Steps to incorporate a business. Incorporating a business involves several legal and administrative steps to establish it as a separate legal entity. The process typically includes: 1. Choose a business name. Select a unique name that complies with state naming requirements. For example, it must include Corporation Incorporated or an abbreviation like Inc. Conduct a name search to ensure the name is not already in use. 2. Appoint directors. Identify the initial directors who will oversee the corporation until the first shareholder meeting. 3. File articles of incorporation. Submit the articles of incorporation, also called a certificate of incorporation, to the appropriate state agency. This document typically includes the corporation's name and address, the purpose of the corporation, the number and type of shares authorized, the names and addresses of the incorporators. 4. Draft corporate bylaws. Create bylaws, which are internal rules governing the corporation's operations, including procedures for holding meetings, roles and responsibilities of directors and officers, voting and decision-making processes. 5. Hold an organizational meeting. Conduct the first meeting of the board of directors to adopt the bylaws. Issue shares to initial shareholders. Appoint officers, for example, CEO, CFO. 6. Obtain necessary licenses and permits. Secure any required federal, state, or local licenses and permits to operate legally. 7. Comply with tax and regulatory requirements. Obtain an employer identification number, EIN, from the IRS. Register for state and local taxes. File annual reports and pay franchise taxes as required. 2 types of business entities. Businesses can choose from several types of legal structures, each with its own advantages and disadvantages. The most common types include: 1. Limited liability company, LLC, features, combines the liability protection of a corporation with the tax benefits of a partnership. Owners, called members, are not personally liable for the company's debts. Advantages: flexible management structure. Pass-through taxation. Profits are taxed at the member level, not the entity level. Disadvantages: more complex to set up than a sole proprietorship or partnership. Limited life, may dissolve if a member leaves. 2. Corporation, features, a separate legal entity owned by shareholders. Provides limited liability protection to shareholders. Advantages, ability to raise capital by issuing shares. Perpetual existence, not affected by changes in ownership. Disadvantages, double taxation, profits taxed at the corporate level and dividends taxed at the shareholder level. More regulatory requirements and administrative complexity. 3. Partnership, features, a business owned by 2 or more individuals, partners. Can be general, all partners manage the business and are personally liable, or limited, some partners have limited liability and no management role. Advantages, easy to establish and manage. Pass-through taxation. Disadvantages, personal liability for general partners. Potential for disputes between partners. 4. Sole proprietorship, features, a business owned and operated by one individual. Advantages, simple and inexpensive to set up. Complete control over business decisions. Disadvantages, unlimited personal liability. Limited ability to raise capital. 3. Understanding corporate bylaws and articles of incorporation. Articles of incorporation. The articles of incorporation are the primary legal document filed with the state to formally create a corporation. They include the corporation's name and purpose, the number and type of shares authorized, the names and addresses of the incorporators, the registered agent, a person or entity designated to receive legal documents. Purpose, establishes the corporation's existence and basic structure. Provides transparency to shareholders, regulators, and the public. Corporate bylaws. Bylaws are internal rules that govern the corporation's operations and management. They typically include procedures for electing directors and officers, rules for holding shareholder and board meetings, voting requirements and decision-making processes, policies for issuing and transferring shares. Purpose, ensures consistent and efficient management of the corporation. Provides clarity on roles, responsibilities, and procedures. Helps resolve disputes by establishing clear guidelines. Conclusion. The formation and structure of corporations are essential steps in establishing a business as a separate legal entity. By following the steps to incorporate, choosing the appropriate business entity, and drafting clear articles of incorporation and bylaws, businesses can ensure compliance with legal requirements, protect stakeholders' interests, and create a solid foundation for growth. Whether forming a corporation, LLC, partnership, or sole proprietorship, understanding these concepts is key to building a successful and sustainable business. Chapter 11. Corporate governance. Corporate governance refers to the system of rules, practices, and processes by which a corporation is directed and controlled. It involves balancing the interests of shareholders, management, and other stakeholders to ensure accountability, transparency, and ethical behavior. This chapter explores the roles and responsibilities of directors and officers, shareholder rights and meetings, and strategies for ensuring compliance with corporate governance standards. Roles and responsibilities of directors and officers. Board of Directors. The Board of Directors is elected by shareholders to oversee the corporation's management and make major decisions. Their primary responsibilities include strategic planning, setting the corporation's long-term goals and direction. Oversight, monitoring management's performance and ensuring the corporation operates in the best interests of shareholders. Risk management, identifying and mitigating risks to the corporation. Fiduciary duties. Directors owe 3 key fiduciary duties to the corporation and its shareholders. Duty of care, making informed and prudent decisions. Duty of loyalty, acting in the best interests of the corporation, not personal interests. Duty of good faith, acting honestly and with integrity. Officers. Officers are appointed by the board to manage the corporation's day-to-day operations. Key roles include: Chief Executive Officer, CEO oversees overall operations and implements the board's strategies. Chief Financial Officer, CFO manages financial planning, reporting, and risk management. Chief Operating Officer, COO oversees daily business activities and ensures operational efficiency. Corporate Secretary, maintains corporate records and ensures compliance with legal and regulatory requirements. Responsibilities: executing the board's decisions and policies. Managing employees and resources. Reporting to the board on performance and challenges. 2. Shareholder rights and meetings. Shareholder rights. Shareholders, as owners of the corporation, have specific rights to ensure their interests are protected. These include: voting rights. Shareholders can vote on major decisions, such as electing directors, approving mergers, or amending bylaws. Dividend rights. Shareholders are entitled to a share of the corporation's profits, if dividends are declared. Information rights. Shareholders have the right to access important corporate information, such as financial statements and meeting minutes. Legal rights. Shareholders can sue the corporation for wrongful acts, such as fraud or breach of fiduciary duty. Shareholder meetings. Shareholder meetings provide a forum for shareholders to exercise their rights and influence corporate governance. Key types of meetings include: Annual General Meeting, AGM held once a year to elect directors, approve financial statements, and address other key issues. Special Meetings, called to address specific matters, such as mergers or amendments to the Articles of Incorporation. Key procedures: notice of the meeting must be sent to shareholders in advance. Shareholders can vote in person, by proxy, or electronically. Meeting minutes must be recorded and maintained as part of the corporate records. 3. Ensuring compliance with corporate governance standards. Compliance with corporate governance standards is essential for maintaining trust, transparency, and accountability. Key strategies include: 1. Adopting best practices. Implement policies and procedures that align with recognized corporate governance frameworks, such as those from the OECD or the National Association of Corporate Directors, NACD. 2. Establishing committees. Create board committees to focus on specific areas, such as: Audit Committee, oversees financial reporting and internal controls. Compensation Committee, sets executive compensation and incentives. Nominating and Governance Committee, identifies and nominates board candidates and oversees governance practices. 3. Promoting transparency, regularly disclose financial and operational information to shareholders and the public. Publish annual reports, sustainability reports, and other relevant documents. 4. Conducting regular audits. Perform internal and external audits to ensure compliance with legal, regulatory, and ethical standards. Address any issues identified during audits promptly. 5. Encouraging ethical behavior. Adopt a code of ethics and conduct training programs for directors, officers, and employees. Establish whistleblower policies to encourage reporting of unethical behavior. 6. Engaging with stakeholders. Foster open communication with shareholders, employees, customers, and other stakeholders. Consider stakeholder interests when making decisions. 7. Monitoring regulatory changes. stay informed about changes in laws and regulations that affect corporate governance. Update policies and practices to ensure ongoing compliance. Conclusion: corporate governance is the foundation of a well-functioning corporation, ensuring accountability, transparency, and ethical behavior. By understanding the roles and responsibilities of directors and officers, protecting shareholder rights, and ensuring compliance with governance standards, corporations can build trust, mitigate risks, and achieve long-term success. Effective corporate governance not only benefits shareholders but also contributes to the overall health and sustainability of the business and society. Chapter 12: Corporate Finance and Securities Law. Corporate finance and securities law are critical areas that govern how businesses raise capital and comply with regulatory requirements. This chapter explores the concepts of equity and debt financing, the regulatory requirements for issuing securities, and compliance with securities laws, particularly those enforced by the U.S. Securities and Exchange Commission, SEC. 1. Understanding equity and debt financing. Equity financing. Equity financing involves raising capital by selling ownership shares in the corporation. Investors who purchase shares, equity, become partial owners and may receive dividends and voting rights. Advantages: no obligation to repay funds, unlike debt. Investors share in the risks and rewards of the business. Disadvantages: dilution of ownership and control. Dividends are not tax deductible. Debt financing. Debt financing involves borrowing funds that must be repaid with interest over time. Common forms include bank loans, bonds, and notes. Advantages: retain full ownership and control of the business. Interest payments are tax deductible. Disadvantages: obligation to repay principal and interest, regardless of business performance. High levels of debt can increase financial risk. Choosing between equity and debt. Businesses often use a combination of equity and debt financing to balance risk, control, and cost. The choice depends on factors such as the company's financial health, growth stage, and risk tolerance. 2. Regulatory requirements for issuing securities. When a corporation issues securities, for example, stocks or bonds, it must comply with federal and state securities laws designed to protect investors and ensure transparency. Key steps in issuing securities. 1. Determine the type of offering. Public offering. Securities are sold to the general public and must be registered with the SEC. Private placement. Securities are sold to a limited number of accredited investors and are exempt from SEC registration. 2. Prepare a registration statement. For public offerings, file a registration statement with the SEC, including a prospectus that provides detailed information about the company, its financials, and the securities being offered. 3. Comply with state laws. Blue sky laws. Register the offering in each state where the securities will be sold, unless an exemption applies. 4. Conduct due diligence. Ensure all information provided to investors is accurate and complete to avoid liability for misrepresentation. 5. Market the securities. Use underwriters, brokers, or other intermediaries to sell the securities, following SEC rules on advertising and solicitation. 6. File ongoing reports. Publicly traded companies must file periodic reports, for example, annual 10-K, quarterly 10-Q, with the SEC to maintain transparency. 3. Compliance with securities laws. SEC regulations. The SEC enforces federal securities laws to protect investors, maintain fair markets, and facilitate capital formation. Key regulations include: Securities Act of 1933 requires companies to register securities offerings and provide full disclosure of material information to investors. prohibits fraud and misrepresentation in the sale of securities. Securities Exchange Act of 1934 regulates securities exchanges, brokers, and dealers. Requires publicly traded companies to file periodic reports and disclose material events, for example, mergers, acquisitions. Sarbanes-Oxley Act of 2002, SOX, enhances corporate accountability and transparency. Requires CEOs and CFOs to certify financial statements and establishes stricter internal controls. Dodd-Frank Act of 2010 expands financial regulation to prevent another financial crisis. Increases oversight of financial institutions and enhances consumer protections. Key compliance requirements: disclosure, provide accurate and timely information to investors, including financial statements, risk factors, and management discussions. Anti-fraud provisions, avoid misleading statements or omissions of material facts in securities offerings and reports. Insider trading rules, prohibit trading based on non-public, material information. Whistleblower protections, encourage reporting of securities violations and protect whistleblowers from retaliation. Conclusion: corporate finance and securities law play a vital role in how businesses raise capital and interact with investors. By understanding equity and debt financing, complying with regulatory requirements for issuing securities, and adhering to SEC regulations, corporations can access the funds they need to grow while maintaining transparency and protecting investor interests. Effective compliance not only ensures legal and ethical business practices but also builds trust and credibility in the financial markets. Chapter 13: Mergers and Acquisitions. Mergers and acquisitions, M&A, are strategic transactions that involve the combination of two or more companies. These transactions can help businesses achieve growth, diversify operations, and gain competitive advantages. This chapter explores the M&A process, legal considerations, and regulatory approvals, including antitrust issues. 1. Understanding the M&A process. The M&A process involves several stages, from initial planning to post-transaction integration. Key steps include: 1. Strategy development, identify the goals of the transaction, such as expanding market share, acquiring new technology, or diversifying product lines. Determine whether to pursue a merger, combining two companies into one, or an acquisition, one company purchasing another. 2. Target identification, identify potential target companies that align with the strategic goals. Conduct preliminary research on the target's financial performance, market position, and cultural fit. 3. Valuation and due diligence, assess the target's value using financial metrics, for example, revenue, EBITDA, market capitalization. Conduct due diligence to evaluate the target's legal, financial, operational, and regulatory status. 4. Negotiation and deal structuring, negotiate the terms of the transaction, including price, payment method, cash, stock, or a combination, and post-transaction governance. Structure the deal as an asset purchase, stock purchase, or merger, depending on tax and legal considerations. 5. Regulatory approvals, obtain necessary approvals from regulatory bodies, such as the SEC, antitrust authorities, and industry-specific regulators. 6. Closing the transaction, finalize the legal documents, including the merger agreement or purchase agreement. Transfer ownership and complete the financial transaction. 7. Post-merger integration, integrate the operations, systems, and cultures of the combined entities. Monitor performance and address any challenges that arise. 2. Legal considerations in mergers and acquisitions. M&A transactions involve complex legal issues that must be carefully addressed to ensure a successful outcome. Key considerations include: 1. Transaction structure, asset purchase. The buyer acquires specific assets and liabilities of the target company. Stock purchase. The buyer acquires the target company's shares, gaining control of its assets and liabilities. Merger. 2 companies combine into one, with one entity surviving and the other ceasing to exist. 2. Contracts and agreements. Letter of intent. Law outlines the preliminary terms of the transaction. Merger agreement or purchase agreement specifies the terms, conditions, and obligations of the parties. Non-disclosure agreement, NDA, protects confidential information shared during negotiations. 3. Due diligence. Review the target's legal, financial, and operational records to identify risks and liabilities. Key areas include contracts, intellectual property, employment agreements, litigation, and regulatory compliance. 4. Employment and labor issues. Address the impact of the transaction on employees, including potential layoffs, benefits, and labor union agreements. Comply with laws such as the Worker Adjustment and Retraining Notification (WARN) Act, which requires advance notice of mass layoffs. 5. Tax implications. Consider the tax consequences of the transaction structure for both the buyer and the seller. Consult tax advisors to optimize the tax treatment of the deal. 6. Intellectual property, IP. Ensure that the target's IP assets, for example, patents, trademarks, copyrights, are properly transferred and protected. 3. Regulatory approvals and antitrust issues. M&A transactions often require regulatory approvals to ensure compliance with laws and protect competition. Key considerations include: 1. Antitrust laws. Antitrust laws, such as the Sherman Act and the Clayton Act in the U.S., aim to prevent anti-competitive practices and protect consumers. Transactions that may substantially lessen competition or create a monopoly are subject to scrutiny by antitrust authorities, such as the Federal Trade Commission, FTC, and the Department of Justice, DOJ. 2. Hart-Scott-Rodino, HSR, Act, requires parties to notify the FTC and DOJ of large transactions and wait for approval before closing. The HSR filing process involves submitting detailed information about the companies and the transaction. 3. Industry-specific regulations. Certain industries, such as banking, healthcare, and telecommunications, have additional regulatory requirements. For example, bank mergers require approval from the Federal Reserve or the Office of the Comptroller of the Currency, OCC. 4. International approvals. Cross-border transactions may require approvals from regulatory authorities in multiple jurisdictions. Compliance with foreign antitrust laws and investment regulations is essential. 5. Mitigating antitrust risks. Conduct a thorough antitrust analysis during the due diligence process. Consider divestitures or other remedies to address potential anti-competitive effects. Engage with regulators early in the process to address concerns and expedite approvals. Conclusion: mergers and acquisitions are powerful tools for achieving strategic business objectives, but they involve complex legal, financial, and regulatory considerations. By understanding the M&A process, addressing key legal issues, and navigating regulatory approvals and antitrust concerns, businesses can successfully execute transactions that drive growth and create value. Effective planning, due diligence, and compliance are essential to ensuring a smooth and successful M&A transaction. Chapter 14: Corporate Compliance and Ethics. Corporate compliance and ethics are essential for maintaining legal and ethical standards in business operations. A strong compliance program helps organizations prevent violations, mitigate risks, and promote a culture of integrity. This chapter explores the development of a corporate compliance program, understanding anti-corruption laws, and strategies for promoting ethical corporate behavior. 1. Developing a corporate compliance program. A corporate compliance program is a structured framework designed to ensure that an organization adheres to legal and regulatory requirements, as well as internal policies and ethical standards. Key components include: 1. Leadership and oversight. Establish a compliance officer or compliance team to oversee the program. Ensure that senior management and the board of directors are committed to compliance. 2. Risk assessment. Identify and assess compliance risks specific to the organization's industry, operations, and geographic locations. Prioritize risks based on their likelihood and potential impact. 3. Policies and procedures. Develop and implement written policies and procedures that address key compliance areas, such as anti-corruption, data privacy, and workplace safety. Ensure that policies are clear, accessible, and regularly updated. 4. Training and communication. Provide regular training to employees, managers, and third parties on compliance policies and procedures. Foster open communication channels for reporting concerns or violations. 5. Monitoring and auditing. Conduct regular audits and reviews to assess the effectiveness of the compliance program. Use monitoring tools to detect and address potential compliance issues. 6. Reporting and investigation. Establish a confidential reporting mechanism, such as a hotline, for employees to report compliance concerns. Investigate reported issues promptly and take appropriate corrective action. 7. Enforcement and discipline. Enforce compliance policies consistently and fairly. Impose disciplinary actions for violations, regardless of the employee's position. 8. Continuous improvement. Regularly review and update the compliance program to address new risks and regulatory changes. Incorporate feedback from employees, audits, and investigations. 2. Understanding anti-corruption laws. Anti-corruption laws are designed to prevent bribery and unethical practices in business transactions. Key laws include: Foreign Corrupt Practices Act, FCPA, scope, applies to U.S. companies, their employees, and agents, as well as foreign companies listed on U.S. stock exchanges. Prohibitions, prohibits bribing foreign officials to obtain or retain business. Accounting provisions, requires accurate record keeping and internal controls to prevent bribery. UK Bribery Act, scope, applies to UK companies and individuals, as well as foreign companies conducting business in the UK. Prohibitions, prohibits bribery of both public and private individuals, as well as offering, promising, or accepting bribes. Corporate offence, holds companies liable for failing to prevent bribery by associated persons, for example, employees, agents. Key compliance measures. Conduct due diligence on third parties, such as agents and distributors. Implement anti-bribery policies and training programs. Monitor and audit transactions for compliance with anti-corruption laws. 3. Promoting ethical corporate behavior. Promoting ethical behavior is essential for building a culture of integrity and trust within an organization. Strategies include: 1. Lead by example. Senior leaders should model ethical behavior and demonstrate a commitment to compliance. Ethical leadership sets the tone for the entire organization. 2. Establish a code of ethics. Develop a code of ethics that outlines the organization's values, principles, and expectations for ethical behavior. Communicate the code to all employees and stakeholders. 3. Encourage ethical decision-making. provide training on ethical decision-making and conflict resolution. Encourage employees to consider the ethical implications of their actions. 4. Recognize and reward ethical behavior. Acknowledge and reward employees who demonstrate ethical behavior and contribute to a positive corporate culture. Highlight ethical achievements in internal communications. 5. Foster open communication. Create a safe and supportive environment for employees to raise concerns or report unethical behavior. Ensure that whistleblowers are protected from retaliation. 6. Integrate ethics into business processes. Incorporate ethical considerations into decision-making processes, such as procurement, hiring, and performance evaluations. Align business goals with ethical principles. 7. Conduct regular ethics audits. Assess the organization's ethical climate and identify areas for improvement. Use the results to strengthen the ethics program and address potential risks. Conclusion. Corporate compliance and ethics are critical for maintaining legal and ethical standards in business operations. By developing a robust compliance program, understanding anti-corruption laws, and promoting ethical behavior, organizations can mitigate risks, build trust, and achieve long-term success. A strong commitment to compliance and ethics not only protects the organization from legal and reputational harm but also fosters a culture of integrity that benefits employees, customers, and stakeholders. Part 4. Advanced Topics in Business Law. Chapter 15. Intellectual Property Law. Intellectual property, IP, law protects creations of the mind, such as inventions, brands, and artistic works. It plays a critical role in fostering innovation, creativity, and economic growth. This chapter explores the fundamentals of patents, trademarks, and copyrights, strategies for protecting intellectual property rights, and legal issues in IP licensing and enforcement. 1. Understanding patents, trademarks, and copyrights. Patents. Definition. A patent grants inventors exclusive rights to their inventions, preventing others from making, using, or selling the invention without permission. Types of patents. Utility patents protect new and useful processes, machines, articles of manufacture, or compositions of matter, for example, a new software algorithm or medical device. Design patents protect the ornamental design of a functional item, for example, the shape of a smartphone. Plant patents protect new and distinct plant varieties. Duration, typically 20 years from the filing date for utility patents and 15 years for design patents. Trademarks. Definition. A trademark protects symbols, names, slogans, or designs that distinguish goods or services, for example, the Nike swoosh or the Coca-Cola logo. Purpose. Prevents consumer confusion and protects brand identity. Duration. Trademarks can last indefinitely if they are actively used and renewed. Copyrights. Definition. Copyright protects original works of authorship, such as books, music, films, and software. Rights granted. Copyright holders have the exclusive right to reproduce, distribute, perform, display, and create derivative works. Duration. Typically lasts for the life of the author plus 70 years, for works created after 1978. 2. Protecting intellectual property rights. Protecting IP rights is essential for maintaining competitive advantage and ensuring that creators can benefit from their work. Key strategies include: 1. Registration. Patents. File a patent application with the relevant patent office, for example, the U.S. Patent and Trademark Office or the European Patent Office. Trademarks. Register trademarks with national or regional trademark offices to secure legal protection. Copyrights. while copyright protection is automatic upon creation. Registering with the Copyright Office provides additional legal benefits, for example, the ability to sue for statutory damages. 2. Monitoring and enforcement. Regularly monitor the market for potential infringements of IP rights. Take prompt action against unauthorized use, such as sending cease and desist letters or filing lawsuits. 3. Trade secrets. Protect confidential business information, for example, formulas, processes, customer lists, through non-disclosure agreements, NDAs, and internal security measures. Trade secrets do not require registration but must be actively safeguarded. 4. International protection. Use international treaties, such as the Patent Cooperation Treaty, PCT, or the Madrid Protocol, to secure IP rights in multiple countries. Work with local legal experts to navigate foreign IP laws. 5. Employee and contractor agreements. Ensure that employment and contractor agreements include IP ownership clauses, assigning rights to the company for work created during employment or engagement. 3. Legal issues in IP licensing and enforcement. IP licensing. Licensing allows IP owners to grant others the right to use their IP in exchange for royalties or other compensation. Key considerations include scope of license. Define the rights granted, for example, exclusive, non-exclusive, territory, duration. Royalties and payments. Specify the amount, frequency, and method of payment. Quality control. Ensure that the licensee maintains the quality and reputation of the IP. Termination clauses. Outline conditions under which the license can be terminated. IP enforcement. Enforcing IP rights is critical to preventing unauthorized use and maintaining the value of the IP. Key enforcement mechanisms include cease and desist letters, formal notices demanding that the infringer stop the unauthorized use. Litigation, filing lawsuits to seek injunctions, damages, or other remedies. Alternative dispute resolution, ADR, using mediation or arbitration to resolve disputes more efficiently and cost-effectively. Common legal issues, infringement claims, defending against allegations of IP infringement or pursuing claims against infringers. Counterfeiting, addressing the production and sale of counterfeit goods that violate trademarks or copyrights. Cybersquatting, resolving disputes over domain names that infringe on trademarks. Fair use and exceptions, navigating exceptions to IP rights, such as fair use in copyright law or prior use in trademark law. Conclusion: intellectual property law is a cornerstone of innovation and creativity, providing legal protection for inventions, brands, and artistic works. By understanding the fundamentals of patents, trademarks, and copyrights, implementing strategies to protect IP rights, and addressing legal issues in licensing and enforcement, businesses can safeguard their intellectual assets and maximize their value. Effective IP management not only drives competitive advantage but also fosters a culture of innovation and respect for creative contributions. Chapter 16, Employment Law. Employment law governs the relationship between employers and employees, ensuring fair treatment, safe working conditions, and compliance with legal standards. This chapter explores employment contracts and at-will employment, compliance with labor laws such as the Fair Labor Standards Act, FLSA, and the Occupational Safety and Health Act, OSHA, and strategies for handling disputes and litigation. 1. Understanding employment contracts and at-will employment. Employment contracts. Employment contracts are agreements between employers and employees that outline the terms and conditions of employment. Key elements include: job description, specifies the employee's role, responsibilities, and duties. Compensation, details the salary, wages, bonuses, and other forms of payment. Benefits includes health insurance, retirement plans, vacation time, and other perks. Duration specifies whether the employment is at will, fixed term, or indefinite. Termination clauses outlines the conditions under which the contract can be terminated, including notice periods and severance pay. Confidentiality and non-compete clauses protects the employer's proprietary information and restricts the employee's ability to work for competitors. At-will employment. At-will employment is a common doctrine in the United States, allowing employers to terminate employees at any time for any reason, except illegal reasons, and employees to resign at any time. Exceptions to at-will employment: implied contracts. If an employer's actions or statements imply job security, courts may find an implied contract. Public policy. Employees cannot be terminated for reasons that violate public policy, for example, refusing to commit an illegal act. Good faith and fair dealing. Some states require employers to act in good faith and deal fairly with employees. 2. Compliance with labor laws. FLSA, OSHA Fair Labor Standards Act, FLSA. The FLSA establishes minimum wage, overtime pay, record keeping, and child labor standards. Key provisions include minimum wage. Employers must pay at least the federal minimum wage, currently $7.25 per hour, though many states have higher minimum wages. Overtime pay. Non-exempt employees must receive overtime pay at 1.5 times their regular rate for hours worked beyond 40 in a work week. Child labor restricts the types of jobs and hours that minors can work. Record keeping. Employers must maintain accurate records of hours worked and wages paid. Occupational Safety and Health Act, OSHA. OSHA ensures safe and healthful working conditions by setting and enforcing standards. Key requirements include workplace safety standards. Employers must comply with OSHA standards for hazards such as chemicals, machinery, and fall protection. Employee rights. Employees have the right to a safe workplace, to report hazards, and to receive training on safety practices. Inspections and penalties. OSHA conducts inspections and can impose penalties for violations. Other key labor laws. Family and Medical Leave Act, FMLA provides eligible employees with up to 12 weeks of unpaid, job-protected leave for certain family and medical reasons. Equal Employment Opportunity, EEO, laws prohibit discrimination based on race, color, religion, sex, national origin, age, disability, or genetic information. 3. Handling disputes and litigation. Employment disputes can arise from issues such as wrongful termination, discrimination, harassment, wage and hour violations, and workplace safety. Effective strategies for handling disputes include 1. Internal resolution, open communication. Encourage employees to raise concerns with supervisors or HR. Mediation. Use a neutral third party to facilitate a resolution between the employee and employer. Grievance procedures. Implement formal procedures for employees to file and resolve complaints. 2. Compliance audits. Regularly review employment practices to ensure compliance with labor laws and identify potential issues. Address any violations promptly and implement corrective actions. 3. Legal counsel. Consult with employment law attorneys to navigate complex legal issues and ensure compliance. Seek legal advice when drafting employment contracts, policies, and procedures. 4. Litigation. If disputes cannot be resolved internally, they may escalate to litigation. Common types of employment litigation include wrongful termination, claims that an employee was fired in violation of a contract; public policy, or anti-discrimination laws. Discrimination and harassment, claims based on violations of EEO laws. Wage and hour disputes, claims for unpaid wages, overtime, or other compensation. Retaliation, claims that an employer retaliated against an employee for exercising their legal rights, for example, whistleblowing. 5. Alternative dispute resolution, ADR, use ADR methods, such as arbitration or mediation, to resolve disputes more efficiently and cost-effectively than litigation. Include ADR clauses in employment contracts to require arbitration or mediation before pursuing litigation. Conclusion: employment law is a critical area that ensures fair and safe working conditions for employees while providing employers with clear guidelines for managing their workforce. By understanding employment contracts and at-will employment, complying with labor laws such as the FLSA and OSHA, and effectively handling disputes and litigation, businesses can foster a positive work environment and minimize legal risks. A proactive approach to employment law not only protects the rights of employees but also contributes to the overall success and sustainability of the organization. Chapter 17: International Business Law. International business law governs the legal aspects of cross-border trade, investment, and commerce. It ensures that businesses comply with international regulations and navigate the complexities of global markets. This chapter explores international trade laws, legal considerations in cross-border transactions, and compliance with international regulations such as those set by the World Trade Organization, WTO, and the European Union, EU. 1. Understanding international trade laws. International trade laws regulate the exchange of goods, services, and intellectual property across national borders. Key areas include: 1. Trade agreements, bilateral agreements, agreements between two countries to reduce trade barriers, for example, tariffs, quotas. Multilateral agreements, agreements involving multiple countries, such as the North American Free Trade Agreement, NAFTA, or the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, CPTPP. 2. Tariffs and customs. Tariffs are taxes imposed on imported goods, while customs regulations govern the import and export of goods. Businesses must comply with customs documentation, valuation, and classification requirements. 3. Trade remedies. Anti-dumping duties, imposed on imported goods sold below fair market value to protect domestic industries. Countervailing duties, imposed to counteract subsidies provided by foreign governments to their exporters. Safeguards, temporary restrictions on imports to protect domestic industries from sudden surges in imports. 4. Export controls, regulations that restrict the export of certain goods, technologies, or services for national security or foreign policy reasons. Examples include the U.S. Export Administration Regulations, IA, and the International Traffic in Arms Regulations, ITA. 2. Legal considerations in cross-border transactions. Cross-border transactions involve unique legal challenges due to differences in laws, regulations, and business practices. Key considerations include: 1. Contract law. Draft clear and comprehensive contracts that address jurisdiction, governing law, dispute resolution, and currency exchange. Consider using international contract templates, such as the International Chamber of Commerce, ICC, Incoterms, to standardize trade terms. 2. Intellectual property, IP, protection. Ensure that IP rights are protected in all relevant jurisdictions. Use international treaties, such as the Madrid Protocol for Trademarks or the Patent Cooperation Treaty, PCT, for patents, to secure global IP protection. 3. Taxation. Understand the tax implications of cross-border transactions, including double taxation treaties and transfer pricing rules. Comply with local tax laws and reporting requirements. 4. Currency and payment risks. Manage risks related to currency fluctuations and payment defaults. Use financial instruments, such as letters of credit or currency hedging, to mitigate risks. 5. Compliance with local laws. Ensure compliance with the laws and regulations of each country involved in the transaction. Work with local legal experts to navigate foreign legal systems. 6. Dispute resolution. Include dispute resolution clauses in contracts, specifying the choice of law, jurisdiction, and arbitration or mediation procedures. Consider using international arbitration institutions, such as the International Center for Settlement of Investment Disputes, ICSID, or the ICC International Court of Arbitration. 3. Compliance with international regulations. WTO, EU directives, World Trade Organization, WTO. The WTO is an international organization that regulates global trade and resolves trade disputes. Key functions include trade negotiations, facilitating negotiations to reduce trade barriers and create new trade rules. Dispute settlement, providing a mechanism for resolving trade disputes between member countries. Monitoring and enforcement, ensuring compliance with WTO agreements and trade policies. European Union, EU, directives. The EU issues directives that member states must implement into their national laws. Key areas include data protection. The General Data Protection Regulation, GDPR, sets strict rules for the collection, storage, and processing of personal data. Consumer protection. Directives ensure fair treatment of consumers in areas such as product safety, advertising, and contract terms. Competition law prohibits anti-competitive practices, such as cartels, abuse of dominant market positions, and state aid. Other international regulations. United Nations Convention on Contracts for the International Sale of Goods, CISG, provides a uniform framework for international sales contracts. Basel III, International Regulatory Framework for Banks, addressing capital adequacy, stress testing, and liquidity risk. Foreign Corrupt Practices Act, FCPA, and UK Bribery Act, anti-corruption laws that apply to businesses operating internationally. Key compliance strategies. Conduct due diligence, research and understand the legal and regulatory requirements in each country of operation. Implement compliance programs, develop policies and procedures to ensure adherence to international regulations. Train employees, provide training on international trade laws, anti-corruption measures, and data protection requirements. Monitor and audit, regularly review compliance practices and address any issues promptly. Conclusion. International business law is essential for navigating the complexities of global trade and ensuring compliance with international regulations. By understanding international trade laws, addressing legal considerations in cross-border transactions, and complying with regulations set by organizations such as the WTO and the EU, businesses can expand their global reach while minimizing legal risks. Effective compliance and proactive legal strategies not only protect businesses from potential liabilities but also foster trust and credibility in the international marketplace. Part 5. Practical Applications and Continuous Improvement. Chapter 18. Case Studies in Business Law. Case studies provide valuable insights into real-world applications of business law, offering lessons from both successful strategies and legal disputes. This chapter explores successful legal strategies, lessons learned from disputes, and best practices from industry leaders. 1. Successful legal strategies in business. 1. Proactive compliance programs. Example, a multinational corporation implemented a comprehensive compliance program to adhere to the Foreign Corrupt Practices Act, FCPA. The program included regular training, internal audits, and a whistleblower hotline. Outcome: the company avoided significant fines and reputational damage by identifying and addressing potential compliance issues early. 2. Effective contract management. Example, a tech startup used standardized contracts with clear terms and conditions for all its partnerships and vendor agreements. It also included dispute resolution clauses specifying arbitration. Outcome: the startup minimized legal disputes and resolved conflicts efficiently, saving time and resources. 3. Intellectual property protection. Example, a pharmaceutical company invested in global patent protection for its new drug, filing applications under the Patent Cooperation Treaty, PCT, and securing trademarks in key markets. Outcome: the company successfully defended its IP against infringement, maintaining its competitive edge and revenue stream. 4. Strategic mergers and acquisitions. Example, a retail giant conducted thorough due diligence and engaged legal experts to navigate antitrust regulations during a major acquisition. Outcome: the acquisition was approved by regulators, and the company expanded its market share without legal setbacks. 2. Lessons learned from legal disputes. 1. Importance of clear contracts. Case: a software development company faced a lawsuit because its contract did not clearly define the scope of work and deliverables. Lesson: always draft detailed contracts that outline all terms, responsibilities, and expectations to avoid ambiguity and disputes. 2. Compliance with labor laws. Case: a manufacturing company was fined for violating the Fair Labor Standards Act, FLSA, by failing to pay overtime wages. Lesson: regularly review and update employment practices to ensure compliance with labor laws and avoid costly penalties. 3. Data privacy violations. Case: a social media platform faced hefty fines under the General Data Protection Regulation, GDPR, for mishandling user data. Lesson: implement robust data protection measures and ensure compliance with data privacy regulations to protect user trust and avoid legal consequences. 4. Antitrust issues. Case: a tech company was investigated for anti-competitive practices, including monopolistic behavior and unfair pricing strategies. Lesson: adhere to antitrust laws and promote fair competition to avoid regulatory scrutiny and legal action. 3. Best practices from industry leaders. 1. Ethical leadership. Example, a leading financial services company established a code of ethics and trained its leaders to model ethical behavior. Best practice: foster a culture of integrity and accountability from the top down to build trust and ensure ethical business practices. 2. Continuous legal education. Example, a global retail chain provided ongoing legal training for its employees on topics such as contract law, intellectual property, and compliance. Best practice: invest in continuous legal education to keep employees informed about relevant laws and regulations. 3. Proactive risk management. Example, an energy company conducted regular risk assessments and implemented mitigation strategies for potential legal and regulatory issues. Best practice: identify and address risks early to prevent legal disputes and ensure business continuity. 4. Stakeholder engagement. Example, a consumer goods company engaged with stakeholders, including customers, employees, and regulators, to understand their concerns and improve compliance. Best practice: maintain open communication with stakeholders to build trust and address potential issues before they escalate. 5. Leveraging technology. Example, a logistics company used contract management software to streamline the creation, review, and tracking of contracts. Best practice: utilize technology to enhance legal processes, improve efficiency, and reduce the risk of errors. Conclusion: case studies in business law provide valuable lessons and best practices for navigating legal challenges and achieving success. By learning from successful legal strategies, understanding the lessons from disputes, and adopting best practices from industry leaders, businesses can enhance their legal preparedness, minimize risks, and foster a culture of compliance and ethical behavior. Continuous improvement and proactive legal management are essential for long-term success in the dynamic and complex world of business law. Chapter 19: Continuous learning and improvement in the ever-evolving field of business law. Continuous learning and improvement are essential for staying compliant, mitigating risks, and maintaining a competitive edge. This chapter explores strategies for staying updated with legal trends, building a legal compliance plan, and developing a personal and organizational legal strategy. 1. Staying updated with legal trends and changes. The legal landscape is constantly changing due to new laws, regulations, and court rulings. Staying informed is critical for businesses and legal professionals. Key strategies include: 1. Monitor legal news and publications, subscribe to legal journals, newsletters, and industry publications to stay informed about recent developments. Examples: the Wall Street Journal Law Blog, Harvard Law Review, and American Bar Association (ABA) Journal. 2. Attend legal seminars and conferences, participate in webinars, workshops, and conferences to learn from experts and network with peers. Examples: ABA Annual Meeting, International Bar Association (IBA) conferences, and industry-specific legal forums. 3. Leverage technology, use legal research tools like Westlaw, LexisNexis, or Bloomberg Law to track updates in case law, statutes, and regulations. Follow legal blogs, podcasts, and social media accounts of thought leaders and law firms. 4. Join professional associations, become a member of professional organizations, such as the ABA, IBA, or local bar associations, to access resources, training, and networking opportunities. 5. Engage legal counsel, regularly consult with legal advisors to understand how new laws and regulations impact your business. Conduct periodic legal audits to ensure compliance with current laws. 2. Building a legal compliance plan. A legal compliance plan ensures that an organization adheres to applicable laws and regulations while minimizing risks. Key steps to build an effective plan include: 1. Conduct a risk assessment, identify areas of legal risk specific to your industry, operations, and geographic locations. Prioritize risks based on their likelihood and potential impact. 2. Develop policies and procedures, create clear, written policies and procedures that address key compliance areas, such as anti-corruption, data privacy, and workplace safety. Ensure policies are accessible and regularly updated. 3. Train employees, provide regular training on compliance policies, legal requirements, and ethical behavior. Tailor training programs to different roles and levels within the organization. 4. Implement monitoring and auditing, conduct regular audits to assess compliance with legal and regulatory requirements. Use monitoring tools to detect and address potential issues early. 5. Establish reporting mechanisms, create confidential channels for employees to report compliance concerns or violations, for example, hotlines, anonymous reporting systems. Ensure whistleblowers are protected from retaliation. 6. Enforce compliance, consistently enforce compliance policies and take disciplinary action for violations. Recognize and reward employees who demonstrate a commitment to compliance. 7. Review and improve. Regularly review and update the compliance plan to address new risks and regulatory changes. Incorporate feedback from employees, audits, and investigations. 3. Developing a personal and organizational legal strategy. A legal strategy aligns legal efforts with business goals, ensuring that legal risks are managed effectively while supporting growth and innovation. Key steps include, for individuals, legal professionals: 1. Set clear goals. Define your career objectives, such as specializing in a specific area of law, advancing to a leadership role, or building expertise in compliance. 2. Invest in continuous education. Pursue advanced certifications, attend training programs, and stay updated on legal trends. Examples: Certified Compliance and Ethics Professional, CIP, Certified Information Privacy Professional, CIP. 3. Build a professional network. Connect with peers, mentors, and industry leaders to share knowledge and opportunities. Participate in professional associations and attend networking events. 4. Develop soft skills. Enhance skills such as communication, negotiation, and problem-solving to excel in your role. Seek feedback and work on areas for improvement. For organizations: 1. Align legal strategy with business goals. Ensure that legal efforts support the organization's mission, vision, and strategic objectives. Collaborate with business leaders to integrate legal considerations into decision-making. 2. Proactively manage risks. Identify potential legal risks and develop strategies to mitigate them. Examples: implement robust data protection measures, conduct regular compliance audits, and draft clear contracts. 3. Foster a culture of compliance. Promote ethical behavior and accountability at all levels of the organization. Encourage open communication and provide resources for employees to report concerns. 4. Leverage technology. Use legal tech tools, such as contract management software, e-discovery platforms, and compliance tracking systems, to improve efficiency and reduce risks. 5. Measure and improve. Track the effectiveness of your legal strategy using key performance indicators, KPIs, such as compliance audit results, dispute resolution times, and employee training completion rates. Continuously refine your strategy based on feedback and changing business needs. Conclusion: continuous learning and improvement are essential for navigating the complexities of business law and ensuring long-term success. By staying updated with legal trends, building a robust compliance plan, and developing a personal and organizational legal strategy, businesses and legal professionals can effectively manage risks, foster ethical behavior, and achieve their goals. A proactive and adaptive approach to legal management not only protects the organization but also drives innovation and growth in a competitive global marketplace. Chapter 20: Overcoming legal challenges. Legal challenges are an inevitable part of running a business, but proactive management and strategic planning can help mitigate risks and ensure long-term compliance. This chapter explores strategies for managing legal risks and disputes, dealing with regulatory investigations, and ensuring long-term legal compliance. 1. Managing legal risks and disputes. Legal risks and disputes can arise from various sources, including contracts, employment issues, intellectual property, and regulatory compliance. Effective management involves: 1. Risk identification and assessment. Conduct regular risk assessments to identify potential legal issues in areas such as contracts, operations, and compliance. Prioritize risks based on their likelihood and potential impact. 2. Clear policies and procedures. Develop and implement clear policies and procedures to address common legal risks, such as contract management, data privacy, and workplace safety. Ensure employees are trained on these policies and understand their responsibilities. 3. Strong contracts. Draft clear, detailed contracts that outline the rights and obligations of all parties. Include dispute resolution clauses, such as arbitration or mediation, to resolve conflicts efficiently. 4. Proactive dispute resolution. Address disputes early through negotiation, mediation, or alternative dispute resolution (ADR) methods to avoid costly litigation. Maintain open communication with stakeholders to resolve issues amicably. 5. Legal counsel. Engage experienced legal counsel to provide guidance on complex legal matters and represent the organization in disputes. Conduct periodic legal audits to identify and address potential risks. 6. Insurance. Obtain appropriate insurance coverage, such as general liability, professional liability, and directors and officers (D&O) insurance, to protect against legal claims. 2. Dealing with regulatory investigations. Regulatory investigations can be stressful and costly, but proper preparation and response can minimize their impact. Key steps include: 1. Preparation. Maintain accurate and up-to-date records of compliance efforts, such as training programs, audits, and policy updates. Designate a compliance officer or team to oversee regulatory matters. 2. Immediate response. Upon receiving notice of an investigation, consult legal counsel immediately to understand the scope and potential consequences. Preserve all relevant documents and data to avoid allegations of spoliation, destruction of evidence. 3. Cooperation. Cooperate fully with regulators, providing requested information and documentation in a timely manner. Avoid making statements or admissions without legal counsel present. 4. Internal investigation. Conduct an internal investigation to identify the root cause of the issue and assess the organization's liability. Use the findings to develop a corrective action plan. 5. Remediation. Implement corrective actions to address the issues identified during the investigation. Demonstrate a commitment to compliance by updating policies, conducting additional training, and improving internal controls. 6. Settlement and resolution. Negotiate with regulators to reach a settlement, if possible, to avoid prolonged litigation and reputational damage. Ensure that any settlement includes clear terms and a plan for ongoing compliance. 3. Ensuring long-term legal compliance. Long-term legal compliance requires a proactive and systematic approach. Key strategies include: 1. Compliance program. Develop and implement a comprehensive compliance program that includes policies, procedures, training, and monitoring. Tailor the program to the organization's specific risks and regulatory requirements. 2. Regular audits and monitoring. Conduct regular audits to assess compliance with legal and regulatory requirements. Use monitoring tools to detect and address potential issues early. 3. Employee training. Provide ongoing training to employees on compliance policies, legal requirements, and ethical behavior. Ensure that training programs are updated to reflect changes in laws and regulations. 4. Stakeholder engagement. Engage with stakeholders, including employees, customers, and regulators, to understand their concerns and improve compliance efforts. Foster a culture of compliance by encouraging open communication and accountability. 5. Technology and automation. Leverage technology to streamline compliance processes, such as contract management, data privacy, and reporting. Use compliance software to track regulatory changes and automate compliance tasks. 6. Continuous improvement. regularly review and update the compliance program to address new risks and regulatory changes. Incorporate feedback from audits, investigations, and stakeholder input to improve compliance efforts. 7. Leadership commitment. Ensure that senior leadership demonstrates a commitment to compliance by modeling ethical behavior and supporting compliance initiatives. Allocate sufficient resources to the compliance program to ensure its effectiveness. Conclusion. Overcoming legal challenges requires a proactive and strategic approach to risk management, regulatory compliance, and dispute resolution. By identifying and addressing legal risks early, responding effectively to regulatory investigations, and implementing a robust compliance program, organizations can minimize legal liabilities, protect their reputation, and ensure long-term success. Continuous improvement and a commitment to ethical behavior are essential for navigating the complexities of business law and achieving sustainable growth.